Good evening, everyone. Welcome to this continued hearing of the Zoning Board of Appeals regarding ZBA FY 2013-12, Grandonico Properties, LLC. This is an appeal. The hearing on this appeal was initially heard on December 20th, 2012. This is a continuation of that hearing. In the interim period, we've received some additional materials from UMass Student Legal Services. In addition, we have a request from the appellant to withdraw the appeal dated January 25th. And there may be some, Jeff, do you know if there are any other new materials in the record that I should call out?
Just that there's a correspondence from Carol Booth dated today, and then the request to withdraw the appeal was dated January 25th, and then there's another correspondence from Carol Booth from January 23rd. So just to separate that, there's actually two different correspondences there.
Okay. So what I wanted to do tonight, on December 20th, we start out with a discussion sort of regarding the scope of the appeal and some legal issues. Talked about the need for some fact-finding and get more information. And so we've done some of that. So I wanted to talk about the information. And I also wanted to, because we didn't have time on the 20th, hear from the building commissioner on the background of the finding of the violation. So I want to do that, and I want to go through some of the factual background before we get to the appellant's request to withdraw. And if there's no objection to that, I guess I'll look to the building commissioner. Mr. Aragood?
It's not an objection, but I would just like to, what I think is clarify that the letter from the appellant on January 25th doesn't request to appeal, to withdraw the appeal. It withdraws the appeal. And the reason I state that is because I believe there's a question that we will resolve tonight, and that is whether an appellant has the ability to withdraw an appeal without requiring that we unanimously vote to approve it. I know that that's been our practice, but it's a practice which I think isn't really supported by either the law or our rules or by reason. But we can discuss that further, but I wanted to say that up front.
Thank you, Mr. Aragood. I guess while we're on the topic, and I'll note that Town Council is here tonight with us. I don't know if you heard the question, Mr. Bard, but
I did, right,
it was my reading of our rules and regulations that we require a unanimous approval. I believe it's Section 2. To withdraw any application after publication requires a unanimous vote of the panel. Is that your understanding?
That's my understanding of the regulation, yes.
Okay. So, Mr. Aragood?
May I just then refer to Article 2.11 of our regulations, which, 2.10, filing and recording, in which in the last paragraph states as follows. Denials, withdrawals of applications, and appeals of a decision of the building commissioner are not recorded at the Registry of Deeds. Now, that doesn't specifically say how a withdrawal takes place, but it does distinguish between a withdrawal of an application and an appeal. It doesn't say a withdrawal of an appeal, but it distinguishes between an application, which in all of its other terms is clearly meant to be an application for a special permit. Because the only question here is whether we're going to treat an appeal as an application. And in this last paragraph of Section 2.11, there's a distinction made between a withdrawal of an appeal, of an application and an appeal. So I believe that that is, how would I say, that's counter to the rule, to the strained interpretation I think we place on our rules that treats an appeal and an application for a special permit as being exactly the same for these purposes.
Well, Mr. Chair, if I can comment on that.
Certainly.
I take that last regulation as more informational I mean, it's a regulation, but I think it reflects the reality. What it's saying is the opposite of what does get recorded. State law requires that a special permit, when granted, is recorded, requires that a variance, when granted, is recorded. The others are not recorded. So I take that regulation as just restating what's a matter of law. In other words, one needn't record an appeal or a withdrawal because it's a non-action. I shouldn't say a non-action, but it's not a recordable event.
Well, I appreciate that the action that's described in section 2.11 is different from what we're talking about, and it's just a recording. But in the way that they are treated as different things. So I'm just saying that in our regulation, we find some places in our regulation where we're saying there's no difference between an appeal and an application. And what I'm pointing to in 2.11 is a place where there is a distinction made between an appeal and an application.
The one thing I'll do is jump in, and I think it's the preceding paragraph that discusses the withdrawal process, and then that paragraph begins with the phrase that any application may be withdrawn, and then there's a two-prong approach, which is before any advertisement has occurred and after an advertisement has occurred. So there was some review of this, and it was determined that the phrase any application worked for the potential withdrawal of an appeal, knowing that the board must vote unanimously to accept that. That was the general understanding.
But
So I'll go along with it, but I just wanted to be clear that I don't believe that an appeal is the same as an application for this purpose. And it seems to me that since an appeal is something that is taken at the instance of a, they're requesting an action. Yes, it's an application for a special permit is requesting an action too, but I see a distinction here which I don't think our practice observes.
Okay, well, I guess we could note this issue for future board business and see if we should make some change. So I was looking now to the building commissioner to maybe walk us through some of the background and update us on where we stand now.
Sure. Inspection Services first became involved with this September 13th. There was a fire in the basement of Unit 28. Unit 28 is one of the units that is subject here in the citation, the 6 units. At that time, Inspection Services also received an email from one of the tenants, bringing concerns about the safety items in the building and requested some assistance. We did reach out to that tenant, and that tenant decided that they were going to work that out with the landlord, so we weren't at that time able to go into their apartment for inspection. We did, however, request that inspections of number 28 as well as a couple other units be looked at in the coming days, and that was because the fire department, during their response to the incident, noted a number of things that concerned us with smoke detectors, carbon monoxide detectors, and living conditions for more than 4 occupants. The owner of the property, Catherine Grandonico, did arrange for an inspection with our full team, joint inspection team, with the health department, building department, and fire department on September 17th, where we were able to view another unit. During that inspection, we found similar concerns that were noted in Unit 28, prompting us to ask again to look at all of the units to get a better picture of what was happening at Gilreath Manor, and we were able to schedule on September 25th 2 more inspections. At that point, I was personally at that inspection with Ms. Grandonico and the rest of the inspection team, and at that point, I suggested that we consider the situation that we've seen in all these apartments similar because of the delay in getting into additional units. And what I'm talking to specifically is the missing smoke detectors, missing carbon monoxide detectors that were viewed in all the units that we did gain access to at that point, including the one with the fire. On October 3rd, I ended up sending a letter, a notice to Grandonico to make the upgrade which is a provision, according to a provision of the building code, in all 14 units. As we discussed, even though I didn't necessarily see all the other units, they acknowledged that the condition was the same throughout. They immediately took action and complied with that order. 10 or so days later, October 12th, a reinspection was done, and those systems were upgraded to current codes and standards in all 14 units as requested. It was during that inspection where we viewed the conditions in 6 of the units that are cited here in this appeal, suggesting that there were more than 4 occupants. Specifically, there's 3 bedrooms on the second floor, and there's a partially finished basement where there was evidence of definitely living quarters for 1 or more occupants, and then there's another space on the opposite side of the finish area. In some cases, that did have the same living conditions. As a result of that inspection, the order was sent ordering Gradonico to take actions to work towards compliance and eliminating the violation in the 6 units that I viewed the condition. What led up to the December 20th hearing, in my opinion, was not enough of a response from Gradonico. And on December 17th, I issued the first citation because I felt they did not comply over that 60-day period with my order and take the necessary steps that I thought were appropriate to work towards compliance. So that got us to December 20th, around December 20th. Since then, I've worked with Mr. Farber to draft a series of conditions that are incorporated in an agreement that brings the property into compliance. Some of the units, 2 of the units are currently in full compliance, 2 out of the 6 that are part of this appeal, and the other 4 have reduced occupancy to 5 and will be in compliance by May 31st. Along with that, there are a number of other upgrades and improvements to the building that is going to ultimately result in a safer property and better living conditions for future occupants. I think that takes us to where we are.
I had a couple of questions, and one relates to the period of time between the fire and the inspections. As I look at the record, and I see, students illegally living in a basement and without, smoke detectors, without carbon monoxide detector, raises a big red flag for me that this is a very dangerous situation. And obviously, what happened at the Rolling Green Apartments, I think, puts an exclamation point on the safety concerns. And so I'm wondering, I know there was a report here from Mr. Roy, and it seemed to me that he was seeking sort of access on the day of the fire to inspect the other apartments to make sure that there wasn't a dangerous condition.
Sure. The request was made immediately once the condition in number 28 where the fire took place was found. We did not get access until 4 days later on the 17th in the first unit. And again, a week later, 2 more units. So we did, obviously, we made the request immediately, and what we were told was that it takes some time to get the permission from the tenants to gain access, and we waited until we were given that time.
Who were you dealing with?
Catherine Gradonico.
Okay. So there's a delay between when the fire happened and the inspection on the 17th, the fire 13th, inspection 17th, and then there was another inspection on the 25th.
Right.
And so that was what Ms. Gradonico was providing by way of access.
That's right.
Okay. And I had a question regarding the fine. that was the ticket that you wrote that imposed a fine for violation of the for unrelated bylaw. Is it your understanding that that there was one violation across, say, for example, 6 units? Is that one violation, or is it one violation for each dwelling?
In this case, I chose to make it one violation for the whole 6 units, not individual units.
Okay. Because certainly there's a, plausible reading, and I'm not trying to second guess you, but that the way Article 12 of the for unrelated bylaw reads, that there would be a violation for each dwelling that had more than 4 unrelated, but
I agree.
you don't disagree, okay. Are there any other questions? Mr. Agood?
I'd like to pose a question to town council on something that you just mentioned. Mr. Bard?
Yes, yeah.
So the delay that Mr. Moore referred to in gaining access was due to the time it took to get approval, is that what it is required from the tenants for an inspection? Is that the correct word, approval? Permission? What's the right word? And after you give me the right word.
I guess it's permission.
Permission. So, would it be possible in a lease that the lease signed by tenants would in advance give permission to, would give that permission for inspection upon, would take, how would I, you know what I'm saying? Would give that permission then to be exercised in some way? I guess it would have to be defined, but nonetheless.
If I understand the question, you mean, could the lease be written so that the tenants would, automatically?
So that there is not a delay in inspection due to waiting for tenants to give permission?
I can answer the question. The answer is yes, and in fact, the lease in this case that was provided to us provides in Section 3 that in emergencies and to effect urgent repairs, advance notice shall not be required.
Well, so this may not be an urgent repair, I'm just.
Right, yeah, I think this is a distinguishable situation. It's just a request to inspect for whatever reason. I mean, Attorney Farber is more of a landlord-tenant expert than I am. I mean, leases are negotiable. I mean, clearly, a landlord doesn't have the right to say, I can come in at any time. I mean, that's really the opposite of, I mean, again, barring an emergency situation. I think the point you're raising in the question is, can a provision be put in for municipal exigencies, if you will, but barring an emergency?
Right.
Let's be clear, we're not talking about emergency, but we have a need to get in sooner rather than later, if you will.
Just to address the situation that we had here, that there wouldn't have been that delay.
Right. I honestly, I can't answer that question off the top of my head. I'd be interested to hear what Attorney Farber has to say, because I suspect he deals with these issues all the time. I mean, my feeling is obviously that it's a toss-up question that I'd have to look into at this point. But if you don't mind throwing the question over there, I'd be interested in the answer.
And I, for my part, have a different take on what that language in the lease means in this case. And specifically, it seems to me reasonable to read that provision to apply to a situation where the landlord denies knowledge of tenants living in the basement. There's been a fire in a basement, and there's not proper smoke detection or carbon monoxide in these basements. It's undisputed. It seems to me that is an emergency situation, and it would have been
my question
appropriate.
was going beyond that specific.
Right, I took the question to be more general. I think I'd agree with you in this situation, that just based on the facts of what had occurred, you could make a good case for it being an emergency to make sure it doesn't reoccur if that condition prevails throughout. But I took the question to be just as a general matter, if someone from the building department feels a need to have to get in for some reason, can they just invoke some clause? I mean, as I said, my initial reaction is quite mixed.
Okay, well, that's not the fact. Those aren't the facts here, but
No,
Ms.
but I'm
Greenbaum?
taking advantage of Mr. Bard's presence here.
Okay.
I'm
Ms.
missing something. I don't see why this is relevant.
Well,
I mean,
yeah.
the end result is the same, whether they had the access a week later or a week earlier, what difference? Whether they wait for the tenant to give them permission to go in and out.
I disagree. I
result
cannot
is the
agree. I cannot agree.
Well,
If
it's
you-
not the
if
same. Okay, I'm
there are
missing
there are
something.
college students living in a basement. There's no smoke detection down there.
Okay.
There's been a fire. They got lucky. There could have been a bad injury or death from this, so they got lucky. But those conditions prevailed in the other units. There were people living in the basement.
Okay, I
There
get
was
that.
no smoke detectors. It's extremely serious. I'm very disturbed by that. And I'm going to talk perhaps at some length about the findings that I think are appropriate in this matter, and then we can have discussion. But
if the tenants understood that there were safety issues there, then if, maybe that wasn't explained to the tenants, or they would have let them come in.
well, I think that's probably maybe what happened. But maybe if if you have another specific question, I'll hear it. But-
No, 'cause, no, I was confused why the time delay became relevant in terms of the end result of why we're sitting here tonight.
I think I have an explanation I'll
Well, if-
offer. I
I'm
think
waiting to
it's
hear
based
that
on
then.
the evidence and inferences I think we can draw from the evidence.
Okay.
So let me do that if
Yeah,
if there's nothing
okay,
else.
if you fill me in of what I'm missing.
Okay, well, let me tell you how I see the evidence. And I'll note for the record that we did request some documents from appellant's counsel, and I do want to give you, obviously, you're going to have time to come up and talk, and I would like to hear from you. But I've reviewed, I think, as carefully as I could, the documentation that is available. So in more or less chronological order, there was a fire called in on September 13th in Unit 28 at the premises. Now, there was a report here from Michael Roy, who's a first responder, and when he arrived there, he asked the residents who were outside, was there anyone else inside the building? There was a basement fire in progress, and they said there was no one else inside. And he asked how many roommates they had, and they said that five people rented the unit. This is I'm looking at the Michael Roy's report from September 14, 2012. And so then Catherine Grandonico arrived, and Mr. Roy advised her of what had happened, that there were no injuries, and that there were a total of 5 residents there. And the report states that Ms. Grandonico denied any acknowledgement that she was renting to 5. And at that time, Mr. Roy asked for permission to inspect the other units. He was concerned, obviously, that there might be unsafe conditions in some of the other units. And his report states that Ms. Grandonico was reluctant to allow this happen, the inspection, stating it was short notice to do an inspection. And so then Mr. Roy asked for 24-hour notice, which Ms. Grandonico said was still not enough time. And then she agreed to have the units inspected on Monday, this 17th of September. And then subsequently, Mr. Roy indicates he received an email from Ms. Grandonico stating that she was encountering difficulties in getting the tenants to allow the fire department to inspect the apartments, but she may have 3 or 4 units to inspect. So this was the first responders' report. I find it credible, and I note that Ms. Grandonico says she didn't know that there were 5 tenants, and in addition, she says that she needs time to arrange the inspections, and actually, in 2 occasions or 3, tried to put off the inspections happening. Now, the next day, there's an email from one of the tenants, and this is an email dated, this would be September 13th or 14th, from Hannah. And Hannah states, I am a student at UMass Amherst and just found out that the basement bedrooms in the apartments my roommates and I are renting are actually in violation of several fire department codes. None of us were aware that these bedrooms were unsafe or unauthorized. This morning there was a fire in a neighboring apartment with the same layout and basement bedrooms, and as a result, quote, we are being asked, this is actually, I'm quoting the whole thing, we are being asked to move our beds out of the basement to make it look like a study for when the fire department comes to inspect all of the apartments on Monday. we are being asked to cover for our realtors. She's sort of asking for advice from John Thompson, who's the building inspector. So what I see here is, what I think is fair to infer, is Ms. Grandonico is on the one hand saying to the town, I need more time, and at the other time, on the other hand, is in contact with the tenants, trying to cover up the fact that they're in violation of the bylaw. There are more emails that support that finding, which I will get to in a moment. And that does, as I said earlier, it disturbs me that in the situation where there's a documented unsafe condition, that any landlord would delay an inspection where there's, again, potentially life-threatening situation for the sake of trying to cover up a violation of the bylaw. There was inspection, as the building commissioner stated, on September 17th, documented other violations of the foreign-related bylaw. There are, pictures that this is all in the record, showing people living in the basement, and the mattress is stacked up against the wall. Now I'm going to jump ahead to October 3rd. There's a notice of violation. This is from the building commissioner, and he discussed this earlier. I would just say that, in this correspondence, he calls out that the fire was found in the basement level, and it was later discovered there were missing smoke detection devices in the unit and no carbon monoxide detection device on the basement level. Later, they conducted inspections and found in other units, Unit 46, 24, 30, no carbon monoxide detection systems that have been properly installed in the basement. Again, the same condition and living conditions in Units 24 and 30. On October 19, the building commissioner details his efforts to try to remedy the situation and relates the results of his inspection of the 14 units, in which he found clear evidence that there were students illegally living in the basement, and he requires a cease and desist of that violation. The building commissioner also states, in discussion with you and your attorney, I have been advised that you had no knowledge of more than 4 tenants in any of the units of Gildearth Manor. And so this is the second time in which Ms. Grandonico has denied any knowledge of violation of the foreign-related bylaw. And then there's the building commissioner's letter from December 17, in which the building commissioner details his efforts again to try to remedy the violation of the zoning bylaw, and that essentially he had not gotten any response from the appellant, and that he was therefore going to initiate fines that would continue daily until the condition had been abated. So that's a piece of the background, and again, I think it's relevant that I think it appeared to be a pattern, I would find, of the appellants not cooperating, even obstructing an inspection that would find the conditions that they did in fact find. I now want to turn to the evidence that was submitted by the UMass attorney, and I think, and I apologize if this seems like it's not a good use of time, but I'm going to actually read excerpts of these materials into the record, because I think it is important, given the gravity of this case, that this material is entered orally into the record. Is there any objection to that? Okay. All right, this is a letter from Attorney Booth, and this was submitted before or around the same time as the December 20th. It's not dated, but around the time of the December 20th hearing. In September and October 2012, I began to see a number of students who were renting apartments at Gildearth Manor on Hobart Lane in Amherst. All of them had more than 4 unrelated housemates, and none were aware of the bylaw prohibiting that practice. I always asked tenants to tell me about when and how they first rented at Gildearth as part of my initial intake interview. They all told me similar stories. Either they had approached the Lincoln Real Estate, Lincoln Rental Office with more than 4 tenants, and all were gladly accepted, or they went to the office with 3 or 4 tenants and were told by Nancy that most units had 5 to 6 tenants because the rent was high and it was easier to share among more tenants. All of them were shown apartments that had more than 4 tenants then currently living in them. In some instances, there were 3 beds in the basement room. Every tenant told me the same thing about the application process. Lincoln took applications from all 5 or more of the prospective occupants. All were required to submit copies of their identification, and all had to sign documents so Lincoln could get information about them from the Dean of Students' office at UMass. No tenants were told it was illegal to have more than 4 tenants. Lincoln's practice is actually to rent to the parents of occupants, who then sublease to their children, so it is actually parents' names on the lease. So Lincoln discussed his practices concerning more than 4 occupants, but no more than 4 signers with the parents as well as the occupants. In some cases where some parents didn't want to be on the lease, Lincoln arranged for other parents in the group to be switched from being non-signers to signers. Let's see, I'm going to skip ahead. A number of tenants reported to me that earlier this fall they were contacted by Nancy or Catherine, who told them there were going to be inspections and they should move their beds so it wouldn't look like anyone was living in the basement, and they should be sure that they were not at home during the inspection. At some of the inspections, Catherine came to the apartment just before the inspection to make sure that the beds had been moved and no tenants would be present. The tenants complied with these requests. 2 of the tenants I spoke to had naively called the fire department after an inspection to ask if they could move their beds back since the inspection was over. They truly had no idea that their tenancies or what they had been asked to do with their beds was illegal or dishonest. After the inspection, the tenants all received Bueno y Sano gift cards from the same landlord, each apartment receiving the same number of gift cards as there were occupants, whether or not the occupants' parents were on the lease. In mid-October, tenants were informed that there would be a second inspection of at least some of the premises. One group of tenants did not understand that the email they received about the inspection meant that they should move all the beds again, so they didn't. When Catherine discovered they had not moved the beds, she was upset with the tenants. After that inspection, they did not receive any gift cards. In October, the landlord received a letter from the town informing him of violations of the bylaw witnessed by the inspectors. In that letter, Building Commissioner Mora confirmed that the landlord and his lawyer had told him that the landlord, quote, had no knowledge of more than 4 tenants in any unit in Gildearth Manor. Within about 2 weeks, the named tenants all received a letter from Lincoln's lawyer informing them that, quote, an alleged violation of your lease has recently been observed at your unit, and explaining the Amherst bylaw. Some tenants had heard about the bylaw by then, but for some, this was the first time they learned of its existence. Mr. Farber included with his letter the letter Lincoln had received from the town. This was the first time extra tenants came to understand that Lincoln was going to deny that it knew their existence. Mr. Farber's letter gave the tenants 30 days to correct the violation. Mr. Farber also sent the tenants a form he created and asked all tenants to sign and return to him, copy attached. The form was a sworn statement by each tenant that only those on the lease were occupying the premises. Most student tenants had no idea what the phrase, quote, signed under pains and penalties of perjury meant. Some student tenants explained to me that they signed the document anyway because it seemed consistent with everything else the landlord asked them to do during their tenancy without explanation, such as hide beds and vacate during inspections. One tenant who asked at the Lincoln office about the purpose of the form was told that it was so there wouldn't be any more inspections. Mr. Farber's 30-day time limit for forcing tenants to correct the violation of the bylaw ended on December 9th, 2012, the day before students' final exam period began. Nevertheless, the letter was effective in forcing a number of student tenants to find alternative housing and move during the end of the semester and finals. Attorney Booth goes on to say that she describes 2 documents from tenants, which she characterizes as being extremely similar to the facts she had just described. Let's see. I think the last paragraph is more general, and it doesn't relate specifically to the facts of this matter, so I'm going to not read that. But Attorney Booth attached an email from Abby Needleman, who is a tenant at Gildraith, and she points out that there's a young woman who was living in number 46 who is not on the lease. And the inference being, of course, that she was an extra tenant in that property. And there's also a statement here from Ms. Needleman dated December 10, 2012, and I'm going to read this into the record. Here is my statement, and please let me know if there's anything else you would like me to discuss. We originally planned to apply for this apartment with either 3 or 4 people because it was advertised as such on the website. However, when we called to ask about an apartment, we were told that most people have 6 or even 7 people live here to cover the cost. At that point, we got together a group of 5 girls to live here. Nancy set up a meeting to show us an apartment, but canceled at the set meeting time. She gave us the phone numbers of the girls living there so that they could give us a tour. The apartment Nancy had sent us to had 6 girls living in it, which supported our decision to follow Nancy's advice and have more people than our original group. While applying for the apartment, all 5 of us had to send in copies of our licenses, signed papers saying Lincoln could get information about us from Whitmore at UMass, and all 5 of our parents had to apply to be on the lease. When we received the lease, it only had the parents of Kristen Cheney, Kara Tesser Nari, and Susanna Gleason. At no point were we told that having 3 people on the lease made any difference from having 4, as we originally were told there would be. We were also not told why 4 people would be put on the lease, and I assumed it was just because the website said it was a 4-person apartment. Kara Tesserina's father chose not to be on the lease, so my mother, Elizabeth Needleman, spoke on the phone with Nancy and convinced them to put her on the lease instead. Throughout the conversation between my mother and Nancy, it was still understood that we would still all be living there. Before moving in, we all went into the office to pick up our keys, but upon arrival, we were told that the parents on the lease had to email Lincoln their permission for the 2 girls not on the lease to have keys. After the emails were sent, the 2 tenants went into the office and received their keys. After the fire in one of the apartments, we received an email about an upcoming inspection. A few days before the inspection, Catherine came by our door when I was the only person home and told me that if we had any beds in the basement, we should hide them. She gave no reasons for this, so I assumed it was because the lease tells us not to have any beds in the basement. However, this did not seem like an issue if the apartment they showed us had beds in the basement. I asked where I should hide them and was told to put them in the upstairs bedrooms and say they were guest beds. We propped them up against the walls, stayed away from the house during the inspection as we had been asked in this email, and heard nothing else from them. A few days later, exactly 5 Bueno Misano gift cards, each for $7, were dropped off while some of my roommates were home. A few weeks later, we received an email about another inspection. Since no one came to tell us to hide the beds, we assumed it was fine to leave them. Susanna Gleason, my roommate, was at home when Catherine came by before the inspection. Susanna asked if it was okay that we didn't move the beds this time. Catherine was very unhappy and asked Susanna to leave until after the inspection. Susanna and I waited outside until Catherine and the inspector had left our house. After both inspections, our doors were left unlocked and the sliding door of the basement was left wide open. So I emailed Nancy about this. Her response was perfectly cordial and did not indicate that anything had gone wrong with the inspection. Suddenly, a couple of weeks ago, we received a letter from the town to Lincoln and a letter from Lincoln to us. The letter from the town stated we had violated a law by having more than 4 people living in our apartment, which was the first time we were hearing about this being an issue. The letter from Lincoln indicated we were violating our lease, which was confusing since we had done nothing that Lincoln was not completely aware of. It indicated that we would have to have 1 person move out by December 9th during finals week, or would be evicted and forced to pay rent for the remainder of the 15-month lease. I emailed Nancy asking why we had been sent this, and she forwarded me an email directly to her lawyer and told me she could not talk to me about it. We received no information from Lincoln as to what this letter really meant and what we should do about it. We were not even sure who should sign it because there were 4 slots to sign, but we only have 3 people on the lease. Because of this letter, one of our roommates has chosen to move out, leaving us to pay the full rent, but we are unable to replace her because we are now being informed that she should not have been living there in the first place. Lincoln misled us into unknowingly having more than the legal limit of unrelated people living together, And now they're suddenly telling us that this is something we should have known all along, when they're the ones who encouraged our current living situation. There's an email from Cara Tesserini, dated December 11th, 2012. This is to Attorney Booth. Hi, Carol. I was the first person to speak with Lincoln Real Estate last March. I called them, so this is March of 2012. I called about their 3-bedroom units at Gildrath Manor. When I spoke to the realtor on the phone, she asked how many people I was planning to live with. We originally were planning to live with 4 people, but she said most people in those complexes live with 5 or 6 roommates because the rent was high. That is when we decided to look for another roommate. We set up a time to show one of the apartments on a Friday at 4 p.m. When we arrived at Hobart, Nancy called me directly and told me she would not be able to make it there to show us the apartment, but gave me the phone numbers to one of the tenants in apartment 28. She said it was part of the tenant's responsibility to show their apartment off to prospective renters. When we arrived at apartment 28, we saw that they had 6 girls living there, 3 upstairs and 3 in the basement. They recommended living with at least 5 or 6 people so rent could be more affordable. I was the first person to put down our security deposit so we could be considered for an apartment. Over spring break, Nancy called my cell phone and told me congratulations, we got apartment 46 of Gildrath Manor. They also emailed my parents and I a congratulations email with a lease packet from Catherine. And then my dad was originally one of the leaseholders but switched with Abigail's mother. We were told only 3 or 4 parents had to sign the lease, but 3 parents would be fine. They said it was okay if I was not on the lease, but lived in 46 as an approved occupant. I was given a key before we left for summer break. Lincoln gave out 5 keys to use, 1 to each tenant, 1 to me, and 1 to Megan Matern. All they asked for was my ID and an email approval from the leasers and their parents. They also have all my information on file, such as my license, UMass housing information, email address, cell phone number, home address, my parents' email, my original deposit check from my bank account, and my personal information from UMass. The joint bank account is on my name, and they receive a check from me every month. Nancy called me in mid-October this year about our water check. I originally paid for both water and sewage, but she called to say I paid too much and only need to pay for water. I went to Lincoln the next day and gave them a check for the right amount. I was also able to personally pick up 2 weekend parking passes this November for our apartment. All Nancy told me that day was that we needed to let them know if we planned to break our lease for the next year, since she knew 2 of us were graduating, in parentheses, the 2 not on the lease. After the fire in Hobart 28, my roommate told my other roommate and I that we needed to deconstruct our beds in the basement to make it look like no one else lives down there or like we have extra guest beds. We were unaware at the time that we were breaking any laws. Catherine told us that if we just set up our beds upright in one room, that we would be fine. After the inspection, we received 5 Bueno Misano gift cards, the correct amount for the number of roommates in the apartment. I recently went into Lincoln to speak to Nancy to ask if I had to sign the paper agreement to show our apartment to potential renters. Nancy was not there, but another realtor was, and she informed me not to sign anything if I was not on the lease. The agreement to show form, however, states that all occupants need to sign the paper, and I am an approved document. And then she closes. I will forward the emails to Lincoln sent to me and my parents from last March. There's additional information, emails from tenants that were sent to the board after the December 20th hearing. And I'd also like to read those in the record. And then I think I'll be done with this piece of this. This is an email. The name has been redacted. It's dated January 9, 2013. It's to Attorney Booth. Hi, Carol. My name it's redacted, and I live in, also redacted. We've had 5 people living in our apartment since we moved in. Lincoln told us only 4 people need to sign the lease, and they did not say only 4 people are allowed to. They had all 5 of us sign papers so they could look up our housing history, and we all signed papers and gave them our home address information. Lincoln was most definitely aware that we were going to have 5 people living there. There's a typo. They also knew 5 to 7 people lived in their apartments last year, because that was apparent when we were showed the house on a tour. They gave all 5 of us a key. They knew the 5th key was going to our 5th roommate. They sent all 4 parents on the lease emails requesting permission for them to give the 5th roommate a key. They knew it was for someone living there. We clearly communicated that in person. Lincoln did, in fact, communicate with the 5th member of our household. She went to the realty office multiple times to talk to them and ask questions about her living situation. I personally saw this communication because at least 2 times I went with her. Lincoln did ask us to hide beds after the fire. They told us we could only have 4 beds, and personally told me to hide my bed under the staircase in the basement. The same day they told me to do this, they provided us with 5, not just 4, Bueno y Sano gift cards. My household did receive a letter from their lawyer about having more than 4 people. We didn't know how to react. We first all talked to our parents, then communicated with Student Legal Services at UMass through one of our good friends who works there. We decided not to do anything about it, especially not to sign papers. I'm 100% positive Lincoln knew we would have 5 people living in the house. I find it ridiculous they were trying to say they didn't know. You can use all this information for the meeting on the 31st, but please keep my name and apartment number confidential. There's another email. This is from Kelsey Joyce to, again, Attorney Booth, dated January 22nd, 2013. Hi, Carol. Currently, 34 Hobart Lane has 5 girls living there, but first semester had 7 roommates. 2 went abroad. We are putting together what we have for evidence for you. Rachel Vincent has a parking pass registered to her, which we got from Nancy, and she documented that upon giving the pass to her, and Rachel's not on the lease. Rachel Vincent also had her mother fill out all the lease forms, which were passed in together with the other 4 applications. We left the other 2 roommates off the lease because they were going abroad. We clearly remember passing Rachel's information because she did not get written up at all in the dorms, and we put hers on top. Her mother got all these forms notarized with the bank, and she never got put on the lease. Her mother has copies of these forms. Pictures of the basement were taken when we were showed this apartment with Catherine in spring of last year. Again, that would be spring of 2012. There were 2 beds in the basement when she showed us this apartment and said, quote, "They aren't technically bedrooms. We have to call them studies." There was also a bed on the other side of the basement with the water heater, 3 total in the basement, and 3 upstairs, 1 in each bedroom. And there's a picture that was submitted with the email of the basement with the bedroom in it, or 2 beds. There's also a letter here from a lawyer in Boston, and I'll read this into the record as well. This is from William Tallis to Attorney Booth at UMass, dated January 9, 2013. Dear Carol, Dustin Molino Getz forwarded your email on to Jessica Eiley, who works with me. As you know, on or about September 13, 2012, a fire occurred in the premises rented by him and 4 other people at 28 Hobart Lane, Amherst through Catherine Grandonico and Lincoln Realty. They collected rent from 5 people who they knowingly placed in the apartment. Following the fire, all of Dustin's personal property was thrown out by Lincoln Realty, apparently in an effort to convince town officials that they had not rented the apartment to more than 4 persons, which I understand is something that has habitually occurred by this landlord. My understanding is that the fire was caused by an electrical overload. I asked the building commissioner earlier today if the cause of the fire had been determined, and I guess the answer is that it's undetermined.
It's undetermined.
Okay. So this, I don't know what, I don't know where he's getting, I don't know where Mr. Tallis is getting that from. I believe that the landlord denied that my client was a tenant, failed to make a report to its own insurance company, which by law is required to pay relocation money of $750 to the tenant, regardless of whether or not liability exists. The destruction of his personal property constituted the loss of all his worldly possession. Currently, we are asserting a claim against the landlord's insurance company, Middle Oak Insurance Company in Salem, Massachusetts. Getting the landlord's cooperation as to the identity of our own insurance company was a challenge itself. At the start of his tenancy, the landlord required all 5 tenants to sign forms so that the rental in excess of occupancy allowed was done knowingly. I assume that maximizing occupancy beyond the legal limit was for the purpose of maximizing profit. And then he closes, please let me know if you need more information. And as my understanding, he says that our client was constructively and actually evicted from the premises and no longer resides there. And then there's an email here that includes Dustin as a resident of Unit 28. So I think, I know that's a lot, and I'm sorry that that felt like it was, took a lot of time, but I felt like it was important to put these facts, again, orally in the record. They've been in the written record. Not everyone has access to these materials. And I think I can sort of summarize what findings I think that we can make from this evidence, which is one, that at least as of 2012, Grandonico and Lincoln Realty had knowledge through its agents and representatives, basically Catherine Grandonico and Nancy, that there were in fact more than 4 unrelateds living in certain of their units. I think we can find that they encouraged this practice, and that it was done knowingly on the part of Grandonico and Lincoln. I think that when the fire happened, I would find that Grandonico intentionally sought to delay further inspection of the premises to avoid revealing facts that would show that they were in violation of the foreign related bylaw. I think there were essentially that Grandonico sought to obstruct further inspections. At the same time that was happening, Grandonico was communicating with its tenants, urging them to hide any evidence that there were more than 4 unrelated people living in the apartment, including hiding beds and not speaking with town officials, inspection officials. I think that you know, those facts are fairly found based on the evidence. We don't have any evidence from Grandonico that was requested, and as I said earlier, I find this very disturbing. It's troubling, and it really does appear to me that this landlord sort of acted in a self-serving way when their tenants' safety was at stake, and avoiding further fire inspections or putting them off because they were worried about being found out on this violation of the zoning bylaw. So I would find those facts. Obviously, I don't do this by myself. There are 2 other members of this board, each of whom have a vote in this matter, but that's how I see this case. I without, where I come down on this, and again, without second guessing what the building commissioner did, which I think was entirely appropriate in following his procedures, is that we have evidence that the violations went back to certainly the spring of 2012, but if one wanted to pick a date, certainly by the date of the fire, I don't think there was a question in anyone's mind what was going on at these units. And I think that raises an issue of the appropriateness of a penalty for the period between that time at September 13th and when the first ticket was issued on December, I believe, 17th. The bylaw in section Article 11 provides that, so let me find the page, provides that any violation of provisions of this bylaw, the conditions of a permit granted under this bylaw, or that any decisions rendered by the Zoning Board of Appeals or Planning Board under this bylaw shall be liable to a fine of not more than $100 for each violation. Each day such violation continues shall be deemed a separate offense. And I will distinguish between that language, which is the first paragraph in section 11.45, from the procedures under General Laws, Chapter 40, Section 21D, which is the procedure through which the building commissioner issued the tickets for the violation. That procedure under General Laws, Chapter 40, Section 21, was added by warrant article in, looks like 1988. So the first paragraph pre-existed. This is an additional remedy that was added in 1988 by town meeting. So the first paragraph that I read exists independently of the procedures of the non-criminal disposition. And I think that under Chapter 40, Section 14, we assume the powers of the building commissioner in this appeal, and that I think we can find that a fine under Section 11.545 is appropriate. for these violations, which I see as, again, intentional, knowing, wanton, egregious, and frankly, reckless. And I think we wouldn't really be upholding our duty if we didn't impose an additional penalty, in particular since it appears that this landlord has been able to extract premium rents by knowingly violating the bylaw and renting to more than 4 tenants. And if they're not penalized sufficiently, then essentially they'll have gotten paid for violating the law. So those are my thoughts. I know I just said a lot, but and there's also the request that we need to address, the request to withdraw. But I open it up for discussion. And I also want to, before the hour gets too late, hear if there's anyone in the public who wishes to speak regarding this matter. But I want to hear from the other members of the board. Ms. Greenbaum.
I agree with you in terms of all of the findings, but I'm still confused regarding our role here if the town of Amherst and the lawyer for the property owner have already reached an agreement, which I assume has been signed. Do we have powers granted by anybody that we can overturn an agreement that the town has already negotiated and signed?
I don't know what the terms of the agreement are. My understanding.
And neither do I.
Well, maybe we should hear from the building
I don't know whether
commissioner, but
that's a public document or not.
my understanding is that those fines were issued for a period starting on October 19, I'm sorry, December 17.
December 17th.
Until some date in the future.
Sure.
So what the period that's left unresolved is the period before December 17. And what makes this, I think, case unique is that, again, the building commissioner acted appropriately, but what's happened is facts have come to light subsequently that show that the violation went way back in time.
I understand that,
so
but what power do we have if an agreement has already been negotiated? That's where I'm confused.
I don't know if town council has any thoughts on this.
Well, it's an interesting question. The agreement, resolves, I understand, the non-criminal disposition fines. Is that correct?
The agreement resolves the violation that was cited and puts an end to the assessment of the fine accruing at a daily rate.
And those were non-criminal for the tickets, the
Non-criminal tickets.
ticketing process, right?
That's right.
And
Well, there
maybe-
is, even though it's non-criminal, here's what I'll just tell you what I'm, pardon the pregnant pause, but what I'm puzzling over here is sort of an issue of double jeopardy, which is a criminal concept, that somebody can't be tried twice for the same violation. The interesting issue here is that the zoning bylaw, one section are criminal fines. The ones that come out of the zoning act are criminal fines, and you have to go through a criminal proceeding in district court to collect them. The whole point of the ticketing of the non-criminal procedure is to streamline it, much like a parking ticket. Nearly self-enforcing, not quite, but if people are willing to pay it, more or less self-implementing. What has been resolved then is the non-criminal side, and that's why I'm hesitating here, because double jeopardy is a criminal concept. But I do wonder if there's a due process issue here. What was levied at the outset were non-criminal fines. They've been resolved. I frankly never had it raised to me, can a zoning board then, at this stage, levy criminal fines, which I assume is what you'd be talking about, because I would agree with the point that's just been made. If the non-criminal fines have been levied and an agreement's been reached, maybe, I don't know, maybe the agreement's not final, maybe the board can look into the nature of that agreement, but you see what I'm saying? They're apples and oranges here a little bit, so we need to be focused. Are we talking about the non-criminal fines, which have been levied to a certain level, or for the first time levying criminal fines? Anyway, those are the issues that this raises that we'd have to talk through.
Mr. Ehrgart?
So I see us as having come here because the appellant appealed from an order of the building commissioner, and that it was our job to decide that appeal. I have not conceived of it, and I don't yet, and I still don't, that as a result of the appellant having appealed to us, that we now stand in the position of the building commissioner as though we're looking at this freshly to make whatever determinations we might make based on the facts that are before us. So that's one important legal point that the chair stated, that this appeal puts us in the position of the building commissioner, and that doesn't strike me as being natural. Now I just want to say that I completely share the factual findings. When Mr. Farber was up here at the original hearing, I wasn't soft with you about the basis of your claim that we should overturn the building commissioner's order based on because there wasn't sufficient information about the knowledge of the landlord of the fact of there being more than 4 tenants. I haven't, and I really thought, Mr. Bard, that this was an excess of caution to say that we really needed a great deal more evidence in order to reach that conclusion. So I really share your conclusions, but I just find us in a different posture. I really think that we're here we came here to decide the appropriateness of the building commissioner's order, that the building commission, that issue doesn't even exist before us anymore because it's been resolved. So I certainly am not prepared to go beyond that and make a series of findings and then issue and state and find and impose fines, or pretend that we're the building commissioner and impose fines and criminal fines. The appellant and his party, they didn't come here with any understanding that the civil appeal, if you will, was putting before us a question of criminal penalties. So I take a more restrained view as to what we should do here, but I don't take a more restrained view as to the facts.
I just want to make one quick response, and then maybe we should hear from Mr. Farber. Again, I apologize for the delay in hearing from you. It's Chapter 48, Section 14, Powers of Boards of Appeals, provides that the board can hear appeals in accordance with Section 8 of Chapter 48, and hear applications for special permits, petitions for variances. And says, in exercising the powers granted by this section, a Board of Appeals may, in conformity with the provisions of this chapter, make orders or decisions, reverse or affirm in whole or in part, or modify any order or decision, and to that end shall have all the powers of the officer from whom the appeal is taken, and may issue or direct the issuance of a permit. So what I'm proposing is that we would modify the building commissioner's order to impose the fines on the date of the cease and desist, which he could have done at that time. I think, was following a process.
What were the last 3 words of that section?
Read that
you just read?
again,
Was it
please.
of
Read
a
that
permit?
statement.
The whole thing?
No, just the last 3 words. It was of a permit?
And to that end shall have all the powers of the officer from whom the appeal is taken, and may issue or direct the issuance of a permit.
Okay, so it's not that. So you're saying it's all the powers of the office from which the appeal is taken.
That's my understanding.
Right, and I actually was busily trying to call it up on my iPhone, but that's the way we think of it is that the board stands in the shoes of the building official when they hear an appeal like this.
And so just to complete this thought, and then we should hear from Mr. Farber. And again, I'm not in any way criticizing what the building commissioner did. This appeal was taken from the issuance of the cease and desist order, and I think the building commissioner properly could have, was within his rights, and we would then have those powers in this appeal to issue fines on the day of the cease and desist order. He chose not to do that. He was restrained, and he worked with the appellant to try to correct the situation, which again, I do not second guess that, but these facts have come to light, again, showing how I think egregious these facts are, and that you know, I wonder if he wouldn't have started the fine sooner if he had known some of this information. At the same time, I also want to make clear that my reading of Section 11 does not require knowledge, the level of knowledge certainly, or any knowledge of a violation for the building commissioner to issue a ticket for a violation or to issue a cease and desist order. I believe that under Article 11, the building commissioner has discretion to pursue the actions that he believes will best serve the town and enforce the zoning bylaw. I'm just raising now, in this specific situation, given these facts, would some additional penalty be appropriate? I think the answer is yes. I can't do it on my own. If there's not agreement, then something else will happen. But I just want to explain my position. Maybe we should hear from Mr. Farber. Thank you.
Thank you. Obviously, I'm Attorney Lawrence Farber. I represent the appellants in this matter, Grand Donico Property LLC. I can appreciate on a certain level before I start what appears to be the anger and frustration of the chair. I believe the chair is, unfortunately in this instance, acting beyond the scope of what he has the authority to do in this. And I want to correct some of the factual issues that, although I have withdrawn my appeal because they were raised by the chair, I would like to address some of the ones which I am concerned with, being on the record. And I say this with all due respect. It's not meant in any way as criticism. I just think, first, I want to stress that this was an appeal, and you have to read the language of what was being appealed. The appeal was whether it was appropriate to fine the individual who was being cited. Nothing else was appealed. That, what is going on now, is way beyond the scope of what was requested to be appealed, and I don't think you have that authority. And that's why when I did an analysis as to filing the request to withdraw the appeal, we no longer contested whether or not in this specific instance, whether or not the building inspector had the authority to bring the fines against my clients. We withdrew that. We worked out a resolution. We have paid, my client has actually paid the fines at this point, a substantial amount. We are not talking about $100. We are talking about a substantial amount. I will leave it for the town to discuss the amounts, but it was a substantial amount and a substantial resolution of the situation. So I do want to stress that what was appealed, and that's what this board has the authority to look at, it has been resolved and is beyond what is being raised today, is beyond the scope of that appeal. And for that reason, I don't think you do have the authority to what you're suggesting. If I had appealed something else, it might have been. But in this instance, all that it was, his question is, was the right person being fined? We have agreed, we have withdrawn our appeal because we recognize the building commissioner. In this instance, based on these facts, and we still dispute some of the representations that were made by the students, but I'm not going to go into that. That's not the part that I want to address with this August board. What I want to address with this August board is a few of the concerns that I think is raising some of your level of frustration, understandably, with it. You have several times stated that there was no smoke detectors. I think the building commissioner will tell you that is not true. There was a smoke detector down in the basement. There was not a CO detector. What the fire department and the building inspector's office requested is that they felt that there should be more smoke detectors down there than was there. There was one. They wanted 2 additional smoke detectors placed in the basements to increase the electrical panels servicing those smoke detectors. All of that was done by my clients as quickly as it humanly could be possible by hiring the independent contractors. And that was done within 2 or 3 weeks, not even 10 days, I think it was done, that they got the independent contractors in there. That is not something a landlord has the authority or expertise to be able to do. So it was not the dangerous situation that was being there. The CO2 detector was There's a heating element in a different part of the basement that they felt, which does work on gas or propane, I don't remember which one it is, and that was the concern with the CO, and they have been installed also. So it is not the same kind of thing where we were allowing people to live without smoke detectors. In fact, I have a email that I'd like to tell you from the person who actually caused the fire. The fire was caused, and I respectfully submit that there was a finding of the fire. They didn't find the exact cause, but they found it was caused on a bed from an electrical device being left, turns out it was a curling iron, on the bed that caused the bed to catch fire. So it was nothing that was inherently wrong with any of the electrical systems or the layout or something else relating to the conditions of the premises. It was a tenant negligence that caused the situation. Non-intentional, we are not suggesting in any way it was that. Katie Fishman was the individual who was living in the basement of number 28 at the time that the fire occurred, and she wrote on October 2nd, Dear Lincoln Realty, just for your information, I work with the AFD, that's Amherst Fire Department, and some of them know me personally. None of the fire detectors were tampered with. In fact, the first thing I did when I moved into the apartment was check the fire detectors to make sure they all worked. Also, I would like you to let you know that when we previously had fire extinguishers in the basement before the fire, I noticed there was no labels on the extinguishers. That indicates, it goes on other issues that I don't think is relevant here, but I wanted to point out that she checked the smoke detectors when she moved in to make sure there was, and there wasn't even, there was in the basement. So I want to stress that it wasn't a situation. Now I want to address the second part of this, which is some of the concern about the alleged delay. And this brings up the question that was raised by Mr. Airgood in respect to what is the rights. And I respectfully submit that, and this has been litigated in housing court, the lease language that gives us permission to go into a premises outside of an emergency only gives us the right to request. Even though the lease language says we're entitled to go in on 24 hours notice, the law states that that just gives us the right to request permission to go in 24 hours. Without that, we cannot. Tenants are the ones who have rights of possession. Once you rent a premises, you no longer have a right of possession. The Fourth Amendment makes all people secure in their homes. The tenants are the ones who it's their homes. Unless there is a compelling exigency that enables you to enter the premises, you have to get their permission. So some of those delays were caused by the tenants themselves, some of whom had illegal individuals in there. We are not suggesting it wasn't. We would submit, by the way, that some of those representations are not accurate, but that is not what I was prepared to do today because I withdrew the appeal. We admitted that there has been a problem. We admitted that there was sufficient evidence for my clients to be fined and for the building commissioner to find that there was a violation, and we have owned up to it, and we have paid a substantial fine in respect to this. I submit that the hearing one side without the other, when there is no issue before you, I can understand how it would get you frustrated and angry hearing one side's without hearing the other side's version of what happened. And
Well, I asked you for your side, and you haven't provided anything.
and that's because we withdrew our appeal because we worked out and faced up to the responsibility of paying the fine and resolving the matter and reaching an agreement with the building inspector on how to go forward to ensure this never happens again. And that is what we have done. We have agreed to add a provision in bold letters, single size of a whole page, on the front of or attached to every lease, which the tenants will have to sign, informing them that there cannot be more than 4 unrelated people in the premises, and the town has a right to fine $100 a day if there is such a violation. That is one of the provisions and one of the agreements that we reached with the building inspector to ensure this will not happen again. There is other provisions relating to how to ensure that the basements are configured in a way that will be conducive to ensuring that these things do not happen in a way again. So I do not want to make it seem as if we did not take this seriously and recognize that there was clearly a problem. And as it went on, we recognized, and as we investigated, that's why we withdrew our appeal. So I want to stress that I believe that what was before this board to hear could be, in this instance, withdrawn. I want to point one other thing out as to that legal issue, if I can. The reason why appeals need an approval when you are dealing with special permits before this board is because if they could withdraw it unilaterally, there is the requirement that if you have a special permit and it is denied, you're not allowed to make a reapplication for a special permit for a period of 2 years. My memory is 2-year period.
That's correct.
That's part of the reason, is to make sure that someone doesn't get it right up to the last minute before they notice they're going to lose, and then they withdraw it, and now they say I can reapply 30 days from here. That is very different than an appeal of the actions of the building commissioner, in which we were questioning whether or not he was charging the right person. We recognize he was. At this point, that stands. I don't know what other authority you would have in that respect, given that we agree. He had the authority to do what he did. And we have actually paid the fine in respect to that. So again, I understand that on the surface this looked bad. Last thing I will say that it's kind of tangential, but I think you would find it instructive. I have represented the last time to you, and I will represent to you again, that many of these representations that happened were done by Nancy, the employee, who went beyond her authority, is our belief. She is retiring. That is also part of what is going to change now as a result of it, because once they were there and in there, I think the landlord's communications to them becomes more difficult. Do we force someone who's already living there out? Do we create an untenable situation of what to do with a person who we recognize may have gotten in there illegally, but now what do we do about it? I think that creates a different communications than allowing them in the first place and encouraging them to have moved in the first place, which is, I think, where we disagree on the facts. We don't disagree once someone was in there that it created a more difficult situation for a landlord to decide, how do I deal now with the fact that there is these people in there? The amount of rent that is charged is the amount of rent. It doesn't matter whether there's 4 people in there, 5 people, 10 people, 100 people. The amount of rent they're going to charge is the exact same. It doesn't get increased with more people in there. With the units that have reduced, the 2 units that did reduce, upon my initial letters, we have given them an agreement that we will only charge them 4/5 of the rent in this specific instance because of the misunderstanding that existed.
Well, let me ask you a question.
But that has nothing to do with this board. I'm telling you that solely because I want you to understand that we are not the ogres that you seem to have gleaned from the information that was placed before you.
Well, thank you very much. And I did have a question. And so you mentioned Nancy, and she was an employee of Lincoln Realty?
Yes, there's no question she's their agent and their bounds.
So she knew that Lincoln she was renting to more than 4 for some of these units?
It is clear that she should have realized. Whether she actually realized or should have realized, we didn't even go into. So, but I would suspect that a reasonable inference could be drawn that she did.
Okay, now what about Ms. Grandonico? There's an email that says that she showed an apartment to a young woman and that there were 3 beds in the basement. Did she know?
And if you remember that exact email that you read, she said these are, and we would submit as to what she actually said, but it was close. she said, this is really not a bedroom, this is a study. Now, the fact that the students then took that to mean that that means we can have it be a bedroom comes up to a question of whether, of what was meant and understood and what was actually said in that instance, but that's not a case that's before you at this point.
But the email said that Catherine showed the apartment, and there were 3 beds in the basement, 3 in the basement, 3 upstairs.
And that is and this is the difficulty, and I understand that it creates, how do I say this? And it's, again, not meaning to insult in any or criticize. Once tenants take possession, they have the rights of possession, and landlord can enter without their permission. While the semester is going on very often, it creates a difficulty of knowing whether they are changing the rules and violating. When the landlord comes in, she only comes in at the time they're showing, at the very near the end of the tenancy, and at that point, there was beds in the basement. Again, it's already an existing situation. She didn't put them down there. She didn't say put 3 people in there. She's showing the apartment to prospective new tenants, and there happens to be that there. And she says to them, it's technically not a bedroom. This is a study. That's what we have a permit for. There was a building permit taken out in 1998 in which they were given permission to create the basements into studies. That's what we have authority to have. It's not like they turn these basements into living spaces without receiving a building permit. They're not bedrooms, and they're not supposed to be. That creates a very difficult, and I understand, and that's the reason why we decided to withdraw the appeal of, could a reasonable inference been drawn that they knew or should have known in this instance? Yeah, that's why we decided it was no longer a question of whether the building inspector had the authority in this instance to do so. But it does create a very difficult and technical and long and drawn out, quote-unquote, trial, and I don't mean trial, but hearing that would be held to make that determination as to who knew what, when, and how. And we didn't feel it was serving a purpose when we have resolved the issue and owned up to it to continue proceeding on that basis before this body.
Yeah, and I appreciate that, and then I'll open up to questions. I appreciate that you've entered into the settlement, but I am deeply troubled by the evidence that I think shows that both Nancy and Catherine knowingly rented to more than 4. And then twice, the documents show that Ms. Grandonico denied to town officials that there were more than 4, that she knew anything about it. That's deeply troubling to me, and I'm not sure where to go with that, counsel. I really am not, but it bothers me, and it bothers me because at the same time that was happening, there were these dangerous conditions where, with the kids living in the basement, and it really rubs me the wrong way. Ms. Greenbaum?
I just wanted a clarification on the status of the basement. You said that 4 people are allowed to live in there. There are 3 bedrooms. I understood from one of the communications that space is not habitable space in the basement. Are there people living in the basement now? What was your agreement about the basement?
We did not address it. It is not a building inspector, nor was it anything relating to his authorities. So that issue has not been addressed one way or the other at this time. The authority of the building commissioner, in this instance, as a zoning officer, which is the only thing that is before this board or this board has the authority on. And again, we have to respect the jurisdictional limits that this board has. Is not before it and has not been addressed. The issue that was raised, claiming that the basements are not habitable, is over ceiling heights only. There is nothing relating to unsafe conditions.
Not
in
egress?
there. What?
Not an issue of 2 egress?
No, there's 2 egresses. There's 2 egresses, there's sufficient light, there's sufficient air exchange, there's all those requirements that meet. The sole issue is that with the drop ceilings, the height is 6'8" instead of 7 feet. But if you removed it, it would be 611 and a half, so it would be technically. And in the fire department was the ones who told us, we don't want you to remove the drop ceilings. It creates a level of additional, they are fire-rated ceilings. Therefore, that was part of the reason why the fire never went any further, was because it was fire-rated and contained it. That's the sole concern in the basements. These are not unsafe basements. These are not situations which are a inherent hazard to people. I want to stress that. For all the faults you may find, and obviously every person is allowed to have their own opinion, and I'm not going to change that, matter how hard I try, your opinion will be your opinion. But if you ask the building commissioner, et cetera, no one has alleged that they create unsafe apartments or that they do not take a serious and responsible steps towards addressing conditions in their premises. They are some of the best maintained premises around, and if I can be so bold, as good as yours, as the properties that I know that you have rented. So that is not the concern with this. And the reason why I want it is because we're not trying to get away with creating unsafe conditions where people are put in a risk of being harmed.
Mr. Airgood? or
So I have
Mr.
a
Gray?
couple of questions for Mr. Farber, but may I ask the building commissioner to, Mr. Farber has described the agreement that he's made with you, and I won't summarize it anyway, but I'd ask you, do you agree with it entirely, with his description of the agreement he's reached with you? And he's also made a number of statements about facts that would be your findings, just most recently about the safety. Do you agree with his statements, or do you?
Yes, Mr. Farber pointed out a couple of the conditions or highlights of the agreement. It's a 10-point agreement. There are a number of things that are being improved in the buildings and improved in their lease agreements and practices. So yes, I agree with the in part description that Mr. Farber gave to the board. I would also agree that from a building code perspective, the basements are in compliance. The ceiling height issue is a sanitary code deficiency that is enforced and being enforced by the health department. We have in our codes differing ceiling heights in habitable spaces. So the conflict would need to be resolved through a request of a variance with the Board of Health, and our agreement also outlines that happen within a time frame. And if successful, then we would move forward into modifications in the basement that are acceptable to myself and the health and fire officials in an effort to reduce the possibility of the basement being used for what we have found in these recent inspections.
So then, from your perspective, both in relation to the four unrelated limitation and building code issues, you are satisfied with the status of, you're satisfied with the situation with this property?
I am. The agreement, it gained us quite a bit for the safety of this property, and also brought some of these issues, forced the property owner to deal with these issues through their lease agreements and notification, which I, question was happening before, certainly given the evidence here. So I think there's substantial improvement moving into the next lease term for this property.
Thank you. Now, a couple questions for you, Mr. Farbers.
I'm here at your disposal.
Thank you very much. So the provision in this statement that's going to be in the lease, that the town has a right to fine $100 a day in the event of more than 4 tenants. Fine whom, does it say?
Well, again, we have reserved, in this instance, we have agreed that we have withdrawn our appeal and have agreed that the building inspector had the right to fine the owners. In future, the question would still turn, in my opinion, on A, whether the landlord knew, and B, what steps the landlord took once they did have a knowledge that there was an illegal situation. That is not the situation that happened here, and that's part of the reason why we have agreed to withdraw our appeal and suffer the consequences of withdrawing that appeal. But in the future, it would, every case, unfortunately, turns on the individual facts in it. If the landlord learns that there's an illegal situation, I believe that what we have agreed in this is that the landlord is going to have to take legal action against the violators in order for them not to be liable to the
So the
town.
tenants are meant to understand that there could be a financial penalty for them if there are more than 4 unrelateds, and what you're saying, that there could be situations in which that financial penalty would fall on the landlord.
That is correct.
So would you be willing to let us, just to give a copy of that statement, that, do we have that as part of the, as
My
part of your settlement,
reluctance-
or could you give that to Mr. Bagg?
All right, Mr. Bagg, I believe, has actually seen it. I do not have a problem in general. Here's my problem, if I might. I do believe anything that's tendered to the town is to some degree a discoverable document as a public document under Freedom of Information Act request. Our main concern, I believe, was for both my client and for the building inspector not necessarily to be hampered by whatever he agreed in this to the next case that may come forward. So from that point of view, it was felt, and to be honest, not to have in the press necessarily misunderstanding why and how we reached the agreement we did in this case. I have no problems with, obviously, the Zoning Board of Appeals seeing it, but I would encourage it not to be made part of the public record for those reasons that I just stated, which is I do not feel it would serve a useful purpose for the town to have this necessarily, because I do believe every case is unique, and how you're going to approach next case
So
may
if
be
we,
different.
if we accept it under those circumstances, it's okay with you?
I believe
All right.
that the town has a right to see it.
Okay, Mr. Bagg, you accept it? You'll accept it?
Yep, if
Okay.
you want to
So
request that document.
the last thing I'd like to, since we're talking about that provision in the lease, is it, just for help, I appreciate what your information about the way housing courts interpret the right of possession. Is it entirely a Fourth Amendment right? Is it,
It's based on the Fourth Amendment. It's also based on contract and case law over the years that have indicated that there is a provision that basically 186 Section 14 of the General Laws of Massachusetts says that a tenant is entitled to quiet enjoyment of their premises. If that quiet enjoyment is violated, the tenant is entitled to 3 times a month's rent or actual damages plus attorney's fees, whichever is greater. That has been interpreted in a number of cases as saying if a landlord enters without permission, that is a violation of their quiet enjoyment. Therefore, in a lease provision, to ask that a landlord automatically require that the tenant give up that right, I believe would be found to be illegal, especially by this housing court, but I believe it actually violates the Constitution because it's asking them to give up their Fourth Amendment rights without reasonable basis for doing so. Emergencies, towns already have the right to enter an emergency. Again, exigent circumstances constitutes valid grounds to void a Fourth Amendment right. Just like if you're chasing a criminal who has committed a crime and they run into a house, if you're in the midst of chasing them, you have a right to enter that house and get them because it's exigent circumstances. On the other hand, if they are in that house and you know they're there, you got to get a search warrant. You can still enter, but you got to get a search warrant. This body has the right to apply to courts for search warrants, or the building inspector, I should say, has that right. They just have to prove probable cause if the tenants aren't granting it. I don't see how a landlord has a right to ask a tenant to give that up without knowledge. I'll point to and I apologize, there's a little afield from what is before this body at this time, but if you have a subsidized tenancy under a Section 8 or some form of a project-based subsidy, in there they have absolute rights to inspect once a year. Even then, you have to give pre-notice, and if they object, there are certain rights that they have to object and not allow you in. So I point that out, that even in federal law, they are granted those kind of rights. It's not an automatic that you can get them to waive it.
Mr. Bagg?
Just two points that were raised, I believe, by Mr. Farber, which I think would be potentially a question for Mr. Bard, the town council, about the scope and jurisdiction of this board has been mentioned a few times. And I'm wondering if Mr. Bard could say a couple words about that. The facts of this case have broadened from the initial appeal, and so I would, on behalf of the board, I'd be asking for Mr. Bard to speak to that for a moment. And then the other item is on the request to withdraw. I think it is a request to withdraw. I don't think it's an as of right to just simply withdraw a case. So I'll let Mr. Bard respond to the first.
Before Mr. Bard responds, as to the request, because the request in this instance is to a narrow issue that was being appealed, I think it's de facto. I don't think it's automatic. I think it becomes, what are you then deciding? You're deciding that the appeal should be upheld. I mean, the rights of the commissioner be upheld. We've already agreed to that. I don't see how that changes in this instance. This is not a special permit or a request for the town to take certain action to begin with. It was solely, did he have the right or did he not have the right to do what he did in this instance? And I think that's a different scenario than if there was a different application before you.
Mr. Bard?
Well, the first question really leads to the second, and when the questions were asked earlier that went pretty broadly, let me say, I addressed them, but I have to say, in the back of my mind, I was thinking the same thing that Attorney Farber was, and that is that the appeal was a narrow appeal. An appellant who comes before a board doesn't expose themselves to wide open jurisdiction, if you will. They are raising a specific question. But actually, as Jeff Bagg just said, it got wider as it went along. So the initial appeal was a very specific, really, question of law. Did the building commissioner, did the town have the ability to levy a fine against the landlord? We answered as a proposition of law, yes, that ability is there. Attorney Farber came back and said, well, you have to show that we knew. And that's what opened the doors, was the inquiry as to what did the landlord know and when did they know it. And that's how we got really into this, much broader inquiry, set of facts, and so forth. I think in a sense what Attorney Farber is saying is it's been closed back down now, but it's a little bit, the barn door's been open, the facts are out there, the facts are of concern. But fundamentally, the issue before the board is simply a question of, can the town levy a fine against the landlord? I think we all agree that legally the question is yes, and I think now factually we all agree that the landlord knew enough. We certainly, I should say on the town side, we, particularly looking at the three of you, from the comments I've heard, all feel convinced that yes, the landlord clearly knew. The applicants, by choosing to settle, if you will, with the building commissioner, as we know, it's not an admission of guilt kind of thing, but
Actually, in this instance, there is no non-admission of guilt. There has been an acknowledgement. To be quite honest, we initially said we'd like to give an administrative fee that was specifically rejected by the building commissioner, saying, no, it's a fine that we're going to agree to. And I think by accepting that we were fined, that my client was fined, I think there was an acceptance as to that in this instance, we believe that there was authority to fine.
All right, thank you for the clarification. So what's happened here is we started with a narrow question. It got appropriately, in my opinion, broadened to get to the factual question of what the property owner and landlord knew. And I will say it's been narrowed back again in terms now of specifically, and this is in a sense sort of wrapping it up, if you will, specifically what action can the board take at this point. I think it has been considerably reined in, and I mean, the board will decide in what direction you want to go, but there's been an acknowledgement of a violation on the specific issue that was raised on appeal. And so I think findings of fact, as the chair was doing, are certainly appropriate, but where it can go beyond that is in my view, fairly limited.
Well, I would, just on the legal issue under Article 11, I think I said it earlier, I'll say it again. I think the building commissioner has discretion to fine an owner with or without knowledge, constructive or actual or otherwise. I think that under my reading of Article 11, doesn't say that there's a precondition of knowledge, and that he's, as a matter of policy, is able to enforce the bylaw against the people who can remedy the violation. And I think that will always include the owner. And that's my reading of the bylaw. The other members of the board may have a different reading. I just think in this case, there are, in addition, there are all these other facts, some of which came to light maybe even after the settlement was reached. And they troubled me. If it's, as I hear town council and the determination of the panel that we don't want to go any further, and again, I don't question anything that the building commissioner did. I think he acted appropriately, and he has my respect. But I was very troubled by these facts, and I want to raise the issue. So if we, however this ends up happening, that's my legal position on Article 11. You know my position on these facts. And whether or not we accept the withdrawal or we go ahead and issue an opinion, I will really, I think, want to hear from.
I have a question.
Do you have, Mr. Eric?
Well,
I think he had his hand up first.
Okay.
So I quite pleased with the building commissioner's testimony as to his sense of the importance of the resolution that was reached. Sounds like it was a pretty far-reaching, completely satisfactory to him solution to all of the building code and zoning issues that are raised by the landlord here with these facts that we found, which have some sharp edge to them. And I'm not going to I find that it's unnecessary to have an opinion about what Article 11, how far it allows me to go, because I'm not going to go beyond supporting the withdrawal of this appeal.
I'm thinking in terms of the logical conclusions here.
Can you speak up a little bit?
Oh, sorry. I'm thinking in terms of the logical processes. What happens if, then what? We have a choice of approving the withdrawal or denying the withdrawal. And suppose we don't have unanimous vote to approve the withdrawal. What are the consequences of that, other than the fact that obviously we can be taken to court? But in terms of actions by members of this body or of the town, other than going to court, what would it mean to not approve withdrawal of an appeal about something that has already been signed and agreed and fines paid to the town? What is our role here? I mean, I think that the question is probably moot, that the action has been taken, an agreement has been made and signed. If we don't have a unanimous vote, what does that mean logically and substantially?
Can I just address that procedural question? I would, in my opinion, and obviously what you're getting at is any decision to take an affirmative step here requires a unanimous vote of the
Right.
three-member board. On the question of whether or not to accept a withdrawal, does the regulation say it has to be unanimous? Oh, it does. All right, I was going to say, be a simple majority, but the regulation says unanimous. Interesting. Okay, never mind.
What does it mean if we aren't unanimous?
If you're not unanimous, it means you have to push on, I guess.
Well,
Oh.
the chair has proposed that we make findings that go beyond the scope of this particular appeal, and that we make findings and we decide on fines and enforcement mechanisms, and in order to do that, that would require unanimous approval, and I won't
Yes.
be part of it.
And if I, to jump in, not necessarily to cut off Mr. Beal, but what I heard was Mr. Beal finding facts. I think his initial run at this
To go
was
beyond it.
finding facts, which is not beyond the scope of this
He has to
case.
go beyond. He
Um,
wanted to go beyond the facts.
And then Mr. Beal proceeded to propose going beyond the finding of facts and the withdrawal. So I think there is an ability to distinguish where Mr. Beal might stand on this, whether or not the board can reach a unanimous on a vote to withdraw. I think Mr. Beal ran through appropriately the facts of this case that didn't get covered very well at the first hearing. That was the findings of facts that Mr. Beal did initially. Then Mr. Beal proposed some additional steps. So the question I think goes back to Mr. Beal as to where do you stand on the additional steps, realizing that the board needs to vote unanimously to withdraw this or proceed in some other direction.
Well, I hear a lack of support for the idea of any additional remedy.
Well, I don't know.
and-
I don't,
Well,
I
I'm
don't
hearing
know
a
what
lack
it
of
means.
support from Mr. Eric.
Oh, okay. I mean, I don't know what
And,
it means.
But I think that given the investment that the town has made, this board, the various people who have given evidence, I think we should decide this issue. This, as town
Decide
council
what?
said, there's a legal issue.
What is
Under
the
Article
issue?
11 of who can have liability for a violation of bylaws. Can a landlord, under, I guess, with or without knowledge, be fined for a violation of a bylaw at their premises?
But
and-
they've already agreed that the landlord, the
But
bylaws
I
say.
want to take the agreement off the table. I don't think imagine the agreement hadn't happened, because I'm
The
not, I don't
bylaw
think we should
says
use
the the property
Listen, let
owner.
me finish, please.
Oh,
I don't
okay.
think we should use the agreement as evidence of liability. I don't think that's proper. But I think what the legal issue has been raised. It's before us. There's now a request to withdraw this. But I think given the investment into consideration of this matter, I think we should, I would not be in favor of granting withdrawal. I would propose that we interpret Article 11 and decide what it means. And I think what it means is that the building commissioner can fine owners for violations of bylaws at the owner's property. It's that simple in my mind as far as that determination.
I apologize, but if I can just say, I don't think what you're requesting is really before you. What is before you is, in this instance, did the building commissioner have the right to fine? That, I think you have the right to decide if you don't want to dismiss this appeal. I don't think what is before you is what does the meaning of Section 11 mean in all instances. And that's not my fight at the moment, but I just respectfully state, I think that the appeal was, did he have the authority in this case to fine, was he fining the right person? If you make the determination, yes, I think that's the end of it. It's a slightly different, again, it's a narrow appeal of what is before you.
Yeah, I'm looking at the, well, where is the letter of appeal? Do you have that, Mr. Farber, in front of you?
I can
I have it.
Let's see, specifically, my clients wish to appeal the portion, this is a letter from council dated October 31st. My clients wish to appeal the portion of your order suggesting that they may be fined for a violation of the zoning bylaw, section 12.152, relating to more than 4 unrelated occupants living in a single dwelling unit for the units that are listed. I do see that as maybe it's a mixed question of, as you may think of it as a mixed question of law and fact, but I see it as simply a determination of law under Article 11. And I think that the answer would be in the affirmative, that the building commissioner does have that authority. And I don't know how the other members of the panel feel about this. And I'll look to Mr. Aragood.
Well, the town council advised us before the first hearing that in order to that the building commissioner's order is supportable only if we find that the landlord had knowledge.
Right.
I'm not prepared, based on the discussions that we've had here, the deliberations, to disagree with that view. It may be that sometime in the future, we should look closely at Article 11. There are quite good reasons to think extending this beyond this particular case and other circumstances in the town under its circumstances, that it might be appropriate and good to have a broader view of Article 11, but I'm not prepared to decide that tonight.
And also, our decisions are not precedent-setting. Each one is judged independently on its merits. And I don't know where you want to go with this. I don't know how we can legally go more than. The decision has been made. It's signed and sealed. I don't think that we as a board have any power to undo a signed decision between the town and some.
You have to speak up
Sorry,
loud.
I don't think that we have the power, from what I've been hearing tonight, to go beyond a signed and sealed agreement. That the landlord admitted culpability and he's paid the fine. I think that's the end of it. That's how I would.
I believe that if we were in a position to construe Article 11 to permit the building commissioner to levy fines whether or not there were knowledge, then that would be relevant to this particular case. It would have made it much easier. We wouldn't have had any trouble at all. But we don't need it. It's not been raised. It's not, we don't need it. It's contrary to the advice that we've gotten from town council. And the basis of the entire resolution is an agreement that there is that knowledge, that therefore doesn't require us to have the broader interpretation of Article 11. I mean, I think that this is like go back into our own deliberations and be thinking about this later, but not now.
Mr. Chair? Yes. Unless there are people from the audience who have questions to ask, I'd like to make a motion.
Well, thank you for the reminder. I did mean to hear from any members of the public who wish to speak, so let's hold on to that thought. And
Could I just ask, just before we leave this, it was a fairly significant thought that seems a little bit incomplete. I'm just curious if there's potentially another action, which is to act on the appeal. The applicant has requested withdrawal of the appeal, but I'm curious, and this is an open-ended question because I'm not sure whether the board could appropriately deny the appeal instead of accepting the withdrawal. I mean,
I would be in favor of affirming the decision of the building commissioner.
and that would be the same idea.
I would be satisfied to leave it at that.
I mean, and that would be a question to confirm with town council, whereas we have been subject to this appeal, and the applicant is now asking that it be withdrawn rather than decided, and I'm hearing Mr. Beal I'm hearing Mr. Beal say we'd like to decide this appeal. Whether it's the narrow scope that Mr. Farber suggests, even that seems to be the question in my mind, is whether the board can actually decide on the appeal rather than accepting the request to withdraw.
Well, let me be practical. In this instance, it wouldn't make a difference because I don't think. I mean, the request has been made to withdraw. There's been a settlement that acknowledges violations, paid a fine. So it seems to me harmless to go ahead and take that action. It's just affirming, in a sense, what's already happened. I mean, it's an interesting question. Can you reject a request to withdraw? I think you can to withdraw because there's no automatic right to withdraw. So I believe you can. And I think in this instance, there'd be no consequence to doing that since it would, in a sense, affirm what has happened.
Thank you. So let's hear from anyone from the public who wishes to speak. Anybody? Okay. Mr. Aragood, how would you like to proceed?
Well, I move to accept the withdrawal by the appellant of the appeal based on the full and complete resolution of the matter that led to this proceeding.
So, Ms. Greenbaum?
Second. I was going to make the same motion, so I will second.
I'm not going to block consensus. I think I made my views on this perfectly clear, and those are on the record. And any future appeals that raise this issue, I think those appellants would be on fair notice of at least my thinking on this matter. So there's a motion to accept the withdrawal. There's a second. Are there any comments from the building commissioner, town council, Mr. Bagg? All right, all in favor? Thank you.